Today we're getting into chapter 14, capacity and legality, two essential ideas that determine whether a contract is actually enforceable or not. So up first, let's talk about contractual capacity, which is simply the legal ability to enter into a contract. Not everyone automatically has this ability. The law protects certain groups, especially minors, intoxicated individuals, mentally incompetent persons. In most cases, contracts involving these individuals are not automatically invalid, but they are voidable, meaning one party has the option to cancel. So, minors are the most commonly tested group when it comes to capacity. A minor can enter into most contracts, but they have the right to disaffirm or cancel the contract. This can happen at any time while they are still a minor, or within a reasonable time after turning 18. When they disaffirm, they must generally return what they still have from the contract. However, there are some important exceptions. For example, minors are still responsible for necessaries like food, shelter, and medical care. Also, once a minor turns 18, they can ratify the contract, meaning they accept it and it becomes fully binding. As for parents, they are usually not responsible for contracts their children enter into, unless they co-sign or the contract involves necessaries. Next up, we have intoxicated individuals. A contract made under intoxication is only voidable if the person was so impaired that they couldn't understand the nature and consequences of the agreement. If they did understand what they were doing, then the contract is still valid. If the contract is voidable, the person can disaffirm it either while intoxicated or shortly after becoming sober. But if they wait too long or continue benefiting from the contract, it may be considered ratified. So, now let's look at mental incompetence. There are three possible outcomes for contracts in this situation. First, if a person has already been declared mentally incompetent by a court, any contract they enter into is void. Second, if they have not been declared incompetent but lacked understanding at the time, the contract is voidable. And third, if the person had capacity at the time, such as during a lucid interval, then the contract is considered valid. So, for a contract to be enforceable, it must also be legal. Contracts that violate statutes include agreements to commit crimes, which are always void, usury, which involves charging illegal interest rates, gambling contracts, which may or may not be enforceable depending on the state, licensing violations, where enforceability depends on whether the law is meant to protect the public or simply raise revenue. Even if a contract doesn't break a specific law, it can still be unenforceable if it goes against public policy. Some key examples include contracts in restraint of trade, like non-compete agreements, which must be reasonable in scope. Unconscionable contracts, which are extremely unfair or one-sided. Exculpatory clauses, which attempt to eliminate the liability but are only enforced under certain conditions. And discriminatory contracts, which are always illegal and unenforceable. In general, illegal contracts are considered void, meaning courts will not enforce them. However, there are some exceptions. If one party was unaware of the illegality, they may be able to recover damages. If a law is designed to protect a certain group, members of that group may still enforce the contract. A party can also withdraw from an illegal agreement before it is carried out. And in some cases, if a contract can be divided into legal and illegal parts, the legal portions may still be enforced. Overall, Chapter 14 is all about two big questions. Does each party have the ability to contract? And is the contract itself legal? If either answer is no, the contract may not be enforceable. Next up, we'll build on this in Chapter 15. I'll see you. Bye.